Hello and welcome to ProfDale's Property Video number 15. This video is about a topic that's often discussed in connection with estates in land and future interests. It's the law of waste. So what do we mean by waste? Well, waste is conduct by the holder of a possessory interest in real estate. In other words, conduct by somebody who currently has possession of the land, and that conduct harms the value of the property and therefore reduces its value for somebody who has a non-possessory interest. Now, there are several possible plaintiffs, people who might sue in waste. One situation, perhaps the most common in law school courses, is the holder of a future interest that follows a life estate. The life tenant commits waste. The holder of the future interest brings a suit, either to enjoin or to get damages for that waste. There are other possibilities. For example, the holder of a future interest that follows a leasehold estate. A tenant leasing property might damage it, and the holder of the future interest, which is usually the landlord that leased out the property to the tenant, is unhappy about it because the property will lose value when they receive it back again. Another possibility is the holder of a mortgage on property. You can understand that if you had a mortgage on property and the holder of the title damaged the property, that would reduce your security interest value, and you'd be very unhappy about that. A final situation, and one we'll talk about in a future video, is a co-tenant who is not in possession. If we have two co-tenants who own land and one of them is in possession and damages the property, the other co-tenant might bring a suit in waste. Those are all possible waste situations. In this video, we're going to focus on waste by a life tenant, and we're going to consider a suit by the holder of a future interest that's going to follow the life estate. That future interest might be a reversion, a remainder, or an executory interest. It really doesn't matter when we focus on the waste. Now, there are four different types of waste that we're going to consider in this video. The first kind is called voluntary waste, and that means that the person committing the waste has done an intentional act. That could be cutting down trees on the property, it could be destroying a building on the property, anything that's intentionally going to damage the real estate. A second possibility, a second type of waste is permissive waste. And that's where the person who's in possession takes no action to preserve the property when they have a duty to take such action. A third possibility is financial waste, and that means that the person in possession has failed to put out some money. For example, they failed to pay the property taxes or to pay the interest on a mortgage on the real estate. A final kind is ameliorative waste. It's one of the most interesting kinds because it's waste that actually improves the value of the property. And if the property can't feasibly be used as it is, then this type of waste may be permitted, and there won't be any liability if the court characterizes it as ameliorative waste. So we can think of many examples of waste. Demolishing a building on the property is sort of the classic example. Cutting timber on the property, that would be waste unless cutting timber is the only feasible use of the land. And if that's true, then cutting timber is allowed. Failing to pay the property taxes on the land, as we mentioned a minute ago, contaminating the property with hazardous waste is a very common kind of waste. Now, you'll recall that permissive waste is liability for failing to do something. So we might ask the question, how much is a life tenant expected to do with regard to repairing the property? What liability do they have if they fail to make repairs? Well, the traditional common law view was a very minimal duty. The life tenant had to keep the property wind and weather tight. So as long as the property wasn't being exposed to the weather, the life tenant had no further liability. But the courts have drifted away from that view, and today probably the majority view is that the life tenant has to repair and maintain the property in a reasonable manner. They don't have to spend extraordinary sums, for example, more than the property's rental value would be worth. And in some states, the duty to make reasonable repairs would include the duty to carry casualty insurance on the property to protect it from, for example, a fire, an earthquake, perhaps a flood, or other casualties. However, if the property is destroyed by a casualty that's not covered by insurance and the life tenant had no duty to carry insurance, and in many states they don't, then the life tenant does not have a duty to rebuild if the property is destroyed by a casualty. How do we measure the damages for waste? Well, let's assume we have property that's owned by A for life, remainder to B. A does damage to the property in the amount of $100,000. Should B be entitled to recover $100,000 right now? Well, that would give B the money before B was expecting to get the real estate, because B has a remainder following A's life estate and therefore doesn't expect to get the property until A dies. So when do we think A is expected to die? Well, let's assume that A is 50 years old, and we check with an actuarial table and determine that A has a 30-year life expectancy at the time of the suit. So instead of giving B the $100,000 right now, what we need to do is to give B the present value of $100,000 right now. In effect, what we're saying is that we'll give B enough money that B can invest it at some reasonable interest rate, and 30 years from now, that money will grow to be $100,000, because 30 years from now is when B legitimately expects to get the property. So let's look at the parameters of our problem. The loss in value is $100,000. The time to elapse until possession is 30 years. We have to determine some interest or discount rate that we'll use in order to compute the present value. What interest rate should we use? Well, this is debatable, but one possibility is to say if B were to invest his recovery in a safe investment with a 30-year duration, what interest rate would B expect to receive? One possible answer to that is that B could put the money in a 30-year government bond. And if we check with the Wall Street Journal or the New York Times in the financial section, we can learn that the current interest rate on 30-year U.S. government bonds is, let us say, 3.4%. So that seems like a reasonable interest rate to use, because if B wanted to, B could actually go out with the money that we give him, buy a bond, hold it for 30 years, and would then have $100,000. Well, now we have all the parameters we need in order to solve our problem. We know that the loss of value is $100,000. We know that the time until B expects to get possession of the property is 30 years, and we've determined that we're going to use an interest or discount rate of 3.4%. We can take these numbers and plug them into a financial table, or more likely today we'd use a financial calculator like the one in the picture, and the answer we'll get will be that the present value of the $100,000 is only $36,676. Now what this means is that if $36,676 were invested in a bond that paid 3.4% interest compounded annually in 30 years, that bond could be redeemed for $100,000. It's remarkable how much the money grows over time if we have a long enough time and a significant interest rate. We might ask ourselves whether plaintiffs should always be able to get damages, and the answer is in some cases it's not really possible to compute the damages in any meaningful way. So if we have a plaintiff whose possession is dependent on conditions the timing of which can't be estimated actuarially, then damages don't make any sense. Can B's value be determined actuarially in the following cases? The first one says to A for life, then to B if B outlives A. Well, this is one that we can solve actuarially. We can determine A's life expectancy, we can determine B's life expectancy, and we can then compute the probability that B will outlive A, and so we can assign a numerical value to the probability of B's getting the property, as well as a time period, namely till the end of A's life, when B would expect to get it. So this one we can compute damages on. It's a little more complicated than the one we did a minute ago, but it can be done. Now consider this possibility. To A but if livestock is ever kept on the property, then to B. What's the probability that livestock will ever be kept on the property? How far in the future will that occur? Well, the answer is there's no way on earth to even estimate that, because putting livestock on the property is purely within A's arbitrary control. So because we can't estimate it actuarially, it doesn't make any sense to try to compute damages for B. Likewise, in this example, to A for life, then to B if B has passed the bar examination. Well, how far in the future will B pass the bar? Will B ever pass the bar? What's the probability of B's passing the bar? The answer is there's no way to compute those figures actuarially, and therefore giving damages to B makes no sense. You'll notice that in these last two cases, even though we won't give damages, a court might still issue an injunction against the waste, particularly if the court thought that the waste was quite egregious and if it was quite unfair to B to allow the waste to occur. Now we're going to talk a few minutes about ameliorative waste. Ameliorative waste is some conduct that actually improves the value of the property. You might scratch your head a minute and think, can you really improve the value of the property by tearing down something on it? But the answer is yes, that's entirely possible if the thing that's there is obsolete and not of any great value. Under some circumstances, the courts will permit ameliorative waste without any liability. Surprisingly, there are very few cases on this topic, and two of them are particularly famous and are referred to in almost all of the property case books, and so we're going to take a little closer look at each of these two cases. The first of these cases is Melms versus Pabst Brewing Company, decided by the Wisconsin Supreme Court in 1899. In this case, a wealthy family in Milwaukee had built what was at that time considered a beautiful Victorian mansion sitting up on the top of a hill, as you can see in the photo. However, over time, the land around the mansion had been converted from residential to industrial use and was really part of the Pabst Brewing Company's factory. So a life tenant, it was an estate for the life of another, but the life tenant demolished the mansion and graded the land down to street level. The people who had the remainder following the life estate sued for damages. They wanted to recover an amount needed to rebuild the mansion, although that probably would have made very little sense, but they wanted the money. The court found that there was no liability and assessed no damages. They said two factors influenced them. The first is that the neighborhood had changed so that residential use of the property was no longer feasible, and the property was worth more with the house demolished than it had been worth when the house was sitting there on top of that hill with industrial land all around it. So this was the classic case of ameliorative waste. The second case is Brokaw versus Brokaw, decided by the New York Court of Appeals back in 1929. Once again, it involves a beautiful mansion built by the wealthy Brokaw family. It passed into the hands of a life tenant, and the life tenant wanted to demolish the mansion on Fifth Avenue in New York City and erect an apartment building in its place. The remainder holders sued, this time not for damages, but for an injunction to enjoin the demolition of the mansion. The court issued the injunction. It refused to find ameliorative waste. The property, admittedly, would be worth more with the house demolished and an apartment building in its place. However, the court found that the neighborhood had only partially changed. There were numerous mansions along Fifth Avenue that had been torn down, but numerous others that still remained and were used either for residential purposes or for institutional purposes. And therefore, the court concluded, it seems, that the neighborhood change was not sufficient to justify the destruction of the mansion. So it refused to permit the destruction. So what are the factors that will lead a court to find no liability because the waste is deemed to be ameliorative? Well, the first factor seems to be that there have got to be changed neighborhood conditions that are so extensive that the present use of the property isn't feasible any longer. Second factor, the change in use will leave the property with at least the same and preferably a greater value. It seems that only if both of those factors are present is a court likely to find that the waste is ameliorative and therefore not to impose any liability for committing it. So that completes our discussion of ameliorative waste. Now we're going to turn our attention to the problem of property that has a mortgage on it. Let's assume that there's a mortgage that covers both the life estate and the remainder. And the question is, who is responsible to make the payments on the mortgage? Well, we can visualize the life estate and remainder as being on a timeline, with the life estate being the present interest and the remainder being the future interest. The rule is that the present interest holder is responsible for the interest payments on the mortgage, and the future interest holder is responsible for any principal payments that come due on the mortgage. Now, in modern times, most mortgages are set up so that every monthly payment is partly interest and partly principal. And what that would seem to indicate then is that the life tenant is responsible for part of each monthly payment, the part that represents interest, and the remainder holder or other future interest holder is responsible for the portion of each monthly payment that represents the principal. To visualize this graphically, let's assume that we have a bank that holds the mortgage on the property, and we have both a life tenant and a remainder holder. Well, the life tenant is responsible for making the payment of interest on every month or whatever other basis the payments are due on to the bank, and the future interest holder, the remainder holder, is responsible for paying the principal. If either one of them doesn't pay their share, then the other one could make the entire payment and come back and sue the one who didn't pay for reimbursement. Here's another interesting question. What if you acquire a life estate and there's already some extractive process going on the property? Are you allowed to continue it? And the answer is the open mine doctrine. The open mine doctrine says if there is an extractive process going on at the time of the grant, the holder of the life estate is allowed to continue it in a reasonable manner. This would apply to an oil well, a mine. It also applies to growing timber on the property. Finally, we ought to say a few words about the judicial remedies for waste. Classically, there are two remedies, and the first one is damages. Remember that because the property isn't expected to pass to the holder of the future interest until some later time, we need to discount the damages to present value. How do we measure those damages? Well, it could be either the reduction in value of the real estate, or it could be the cost to restore the property. Sometimes courts will use one and sometimes the other. The other classic remedy is an injunction, which is an order from the court prohibiting the continuation of conduct that constitutes waste. Now, if you think about these two remedies, you'll realize that in cases where the waste has already been completed, for example, if the waste consists of tearing down a house and the house has already been torn down, it won't do any good to issue an injunction against tearing it down. So as a practical matter, damages are the only remaining remedy in that situation. That wraps up our discussion of the law of waste. In our next video, we'll take up a brand new topic, concurrent ownership. If you have questions or comments, email ProfDale01@gmail.com. And thanks for watching.